This is Live Fire, with the latest news about threats to your liberties and your right to keep and bear arms. Our guests include elected and other public officials, journalists, citizen activists, and others who are fighting for the Bill of Rights, especially the Second Amendment. Live Fire covers a broad range of constitutional issues, particularly the debate over private ownership of firearms. Our host is Larry Pratt, Executive Director of Gun Owners of America. Remember, the issue is not just about gun control. It's about control. Now, here's your host, Larry Pratt.
Hello and welcome to this edition of the Gun Owners News Hour. Live Fire indeed. We're going to talk about something that ought to be in the congressional line of fire, and that's the presidential executive order power. Bill Olson is a constitutional attorney, has done much appellate work for Gun Owners of America. 14 years ago, Bill, you wrote for the Cato Institute one of their policy analyses on executive orders and national emergencies. And it might as well have been written yesterday. It's certainly a problem that we are still haven't really dealt with. The Congress has not done what it could to rein in these abuses of presidential power. And so let's take a look at it. Let's go through this paper that you did, we had presidential orders back in the Washington administration, but it certainly wasn't the kind of thing that we're dealing with today.
The Constitution's pretty clear on this point, that all legislative power is vested in Congress and not in the president, but presidents get frustrated when Congress doesn't do what they're told to do. And,
by them, not the people, but by the president.
So we hear statements coming out of virtually every administration, Republican and Democrat, that say if Congress doesn't get on board, I will act in the national interest. Of course, I being the president. It all began. That type of language began with FDR. Here he gets sworn in. 1 a.m, he signs his first executive order, and just a great phrase where he says, "It's hoped that the normal balance of executive and legislative authority may be wholly adequate to meet the unprecedented task, but it may be that there's an unprecedented demand and need for undelayed action, which means I am prepared to act under the Constitution to solve the problems of a stricken nation." And every president seems to think that whatever is confronting us is a sufficient justification to basically suspend the normal process, the normal separation of powers, the normal process by which Congress writes the laws and the president implements them. It really doesn't matter who they are. The bug has bitten them all.
George Bush was facing the financial crisis, and it was so urgent that they had to act right then. And why, John McCain suspended his presidential campaign to come back to Washington. And I thought, for a minute, silly me, how should I have ever entertained the thought that he might be coming back to do the right thing, because he didn't say which way he was going to vote. But, of course, he went along with more big government and sustained the intervention of the president. Oh, buddy, this is a bipartisan problem. It's a bipartisanship that they can really get around, I think.
You just reminded me of a conversation I had with a congressman who you and I have both known for a long time, who voted in favor of all of the dictatorial powers in order to avoid an economic crisis. And I said, "Why did you do it?" And he said, the head of the Fed came up here and said there was going to be an international collapse of the world economy if we didn't vote for it. And I said, if that's why you voted for it, you're too stupid to be in Congress.
I'm glad you said that.
And every once in a while we have to tell them what we actually think rather than hold the door for them, which is what they're used to.
They need a little tough love, and I don't think they get enough of it. That's something we can discuss on another occasion. We're both very well acquainted with the seduction of power that comes imperceptibly. And this guy had obviously, to use your phrase, been bitten and had a full-blown case of government knows best, in spite of all evidence to the contrary.
but Larry, like you said, this is not new. I mean, this does go back to George Washington, and it's sort of funny. When I was one of the heroes that I've had in my life, I guess, has been reading about Washington and understanding him, and I started working on this paper in '98 or so, and all of a sudden I wanted to go back to see if there was any precedent for Washington to use an executive order. It wasn't called that exactly then, but a presidential directive. All of a sudden I find that on April 22nd, 1793, that President Washington was so concerned that certain Americans might become involved on one side or the other of a war in Europe that he made an announcement of a declaration of neutrality, which is fine. He can speak for the government on that. But he then said if any citizen were to take sides, that the person would be prosecuted, which basically means that he was, by executive order, writing a criminal statute, the penalty for which would be incarceration.
And except for a marshal here or there, to my knowledge, there were no federal constabulary around during that time. So it's a curious notion. Was he, you suppose, going to rely on state and local police powers to apprehend and incarcerate, because they didn't have any federal lockups either?
Well, they managed to gather, quite an army of military to go to western Pennsylvania for the Whiskey Rebellion to suppress that, because Hamilton wanted to make sure that the excise tax on whiskey was not disrespected by the people. And we had... and, of
course, there's clear constitutional grant of authority for taxing whiskey.
Well, we don't worry too much about that anymore. But this is extraordinary. The one thing that happened to Washington, I was thinking, should I put this in the paper or not? Because I thought it reflected rather badly on Washington, and at some point you have to pick truth over your heroes. So I put it in, and what happened in that case was that Congress rapidly followed up on his executive order and actually criminalized the same behavior that he had attempted to criminalize by executive order.
So they joined in the unconstitutional orgy to keep the president company.
There really are so few constitutional warrants for crimes. When we put our website up years ago, one of the first things we put up there was a list of all the provisions of the U.S. Constitution that could conceivably support the existence of a federal crime. And there are very few indeed.
Where would people find that? What is your web address?
Well, it's at lawandfreedom.com.
Good. That's a good list to go get, folks, lawandfreedom.com. And then just look at that and think of all of the amazing number of constabulary we have here at the federal level, starting with 100,000 troops at Homeland Insecurity. What a deal.
Well, actually, on that page, there are two things that might be interesting. One is the under historical documents, it's called U.S. Constitutional Provisions Authorizing Creations of Federal Criminal Offenses. And another is under a tab called Martial Law, which has a memorandum we wrote about the same time we wrote this paper for Cato. And it was an attempt, it was sort of a let's pretend kind of memorandum for the president as White House
Let's come back to that memo, talking with Bill Olson, a constitutional attorney who has represented many people on behalf of Gun Owners of America, Gun Owners Foundation. When we put in Friends of the Court briefs, those are written by Bill and his colleagues at his law firm. And we were talking about the presidential order list that you had up on your site, Bill, lawandfreedom.com. Why don't we pick up there?
One of the topics that many people are increasingly interested in is the issue of martial law and the ability of the president to declare martial law and to be able to use extraordinary powers, police powers, which are normally supposed to be vested by the Constitution in the states and localities and not in the federal government. And back around the time of Y2K, we did a bunch of research on this issue to see what precedents existed for the use of presidential powers to use the armed forces in order to suppress civilian disturbances. And again, it was written May 1999, and quite current. The only thing that's happened since is that George Herbert Walker Bush,
or Bush the first, as we say in our monarchy.
Well, we have Bush 41 and Baby Bush. We have both of them have made it more difficult to control the military. As a matter of fact, we have some weakening of the posse comitatus law, which precludes the use, at least, of Army personnel in ordinary law enforcement in ordinary situations. So we've had an erosion of the protections that were built into these laws that go back to the 1800s. And we decided to catalog the use of presidential powers. Presidents, all too many presidents feel like Richard Nixon, who in that famous David Frost interview said, if a president does it, it means it's not illegal. And there is great, one of the great problems is that there are many lawyers over at the Justice Department, particularly at the Office of Legal Counsel, who have file drawers full of authorities to actually support a premise very similar to that.
Well, that's the attitude that we encounter in this town. The point of view that you have, that we share at Gun Owners of America, is viewed as, at best, oh, bless their hearts, such an antiquated attachment to the Constitution. It's increasingly an open disdain. It's the last thing that's consulted. I have yet to meet an attorney who was not educated along the lines that the First Amendment has a separation of church and state language in it. Everybody knows, and so it's when the Supreme Court ruled on Heller, it obviously left open. Okay, the gun ban is a goner in D.C., but we just haven't discussed what regulation might be appropriate. We'll leave that for the future. Well, the word infringe doesn't seem to be an obstacle for these people.
Well, Congress is not helping themselves. I mean, Larry, you just wrote to Senator Reid asking him to correct the website of the U.S. Senate because it seems to, when they posted the U.S. Constitution, it seems to be unclear to them that the Second Amendment protects an individual right.
Yeah, I guess we need to check and see whether they certainly haven't acknowledged the letter, so it may be that maybe they're just working on the problem, and will get back to us as soon as they.
Well, if we do a follow-up letter, Larry, we can cite President Obama, because in the statement that he released, it's on the White House website. It's called "Now is the Time: The President's Plan to Protect Our Children and Our Communities by Reducing Gun Violence." In there, interestingly enough, there's the statement on page 9, the President believes that the Second Amendment guarantees an individual right to bear arms.
Didn't even say creates a right, which is often something that the statist mind tends to say. That's surprising. I think there must have been somebody on our side messing around with them.
Well, if they listen to this interview, maybe someone will be held accountable. Oh, no one's held accountable in this administration. I forgot.
But of course, they will be listening to the conversation. So,
well, that was an interesting admission. I mean, it was an acceptance of Justice Scalia's position in the Heller case. The Second Amendment does address individual rights. Of course, if you read the rest of what President Obama released, and anytime there's a crisis, elected officials feel they have to fill the void by either criminalizing new behavior, pass a new law to create a new crime, or increase the sanction of a crime that's already on the books.
Yeah,
and that's not just at the federal level, but here Sandy Hook occurs in December of last year, and a month later, he issues this report and begins to make a significant move against gun owners, and so we begin to see the pattern now. Fortunately, because of your work and many other providential circumstances, the gun bill was derailed for now, but they will never, ever go away.
No. They're convinced that they were born to rule, and how can you rule when those who are supposed to be ruled have guns? I don't know much about President Rutherford Hayes, but he may have been arguably one of our best presidents, just based on one reference that you made to him, something he said to the effect that if a Napoleon ever became president, he could make the executive almost what he wished to make it. Aren't we talking about that right now? From Clinton through Bush to Obama, and certainly going back to FDR, you've already made reference. These guys really seem to have a Napoleon complex.
Well, it is tragic. I mean, the President of the United States is the official charged with the duty to take care of the Constitution's enforced, and one would think they would take that seriously, but rather most presidents seem to want to defend the prerogatives of the presidency. And,
right.
We'll be filing a brief soon in the president's attempt to appoint his friends onto the NLRB to be able to change policy there. There are many other...
But what he was doing, by the way, just to build that out a little bit, he was telling the Congress that I can tell you when you are in recess, so that now I can make a recess appointment. The Congress had not put themselves in recess, so the president has become the president of the Senate as well. Isn't that interesting?
Well, I guess that's what he means. He wants to take care of the Constitution. He wants to interpret it exclusively. And, don't forget, Paul Begala said about executive orders, stroke of the pen, law of the land. Kind of cool.
Kind of cool indeed. We'll be back with Bill Olson. Lawandfreedom.com is his website for the constitutional law that he does. Executive orders and national emergencies. You can still find it online. It's there, and it lays out that from the very beginning, presidents have had a tendency to not be able to wait for Congress. Congress is just so slow. And we've got to take action right away, or the Republic will collapse. And that is something that is a bipartisan problem, Republican and Democrat alike. The idea that, well, I was elected, as the president has rather infamously told a Republican group of legislators meeting with him, as if they hadn't been elected, and in the House of Representatives that they didn't have a majority. So the voters send mixed signals, just like politicians. So I guess if we have a double-minded electorate, we shouldn't be too surprised that we have a double-minded ruling class. So anyway, I guess what you did, Bill, was to trace the modern cancer back in the 20th century, starting with that famous Republican, Teddy Roosevelt, who was, after all, a progressive, which is today's word for socialist. He was for national health care. This was not really a good thing. And we haven't, I don't think we've articulated an effective comeback to what these presidents are saying, because they use crises as the bludgeon to get us to submit. One of the more infamous uses of the bludgeon was to intern the Japanese. Turns out that Democrats are kind of racist. Wilson resegregated the military after it had been desegregated. And here you got FDR getting all those Japanese people rounded up so they're not going to be a threat, all by executive order.
That Korematsu decision where the Supreme Court authorized the rounding up of the Japanese along the West Coast was approved by the Supreme Court in the first case that they ever had using their balancing tests.
Let's explain that to folks, because that's a real bad concoction.
Yeah, it really is, and it bears strongly on this area of executive orders also. The Constitution, we take a rather simple position, which is the Constitution means what it says, and should be applied according to the authorial intent of the framers.
And it wasn't written in Nahuatl, the language of the Aztecs. It was written in pretty clear English.
And that language had to be clear because originally the Constitution was ratified by conventions in 9 states, and all the amendments thereafter have undergone significant public scrutiny. So it's normally uses ordinary language. There's some technical terms that invoke concepts of English law and such, but normally quite clear. We have difficulty, however, with the concept of a living constitution. Well, a living constitution is no constitution at all. It's a constitution that isn't written. It's one that the justices and judges make up as they go. And the Korematsu case, this terrible decision that eventually the Congress had to apologize for, that was decided, the first case decided under what was considered strict scrutiny. They didn't use the phrase strict scrutiny, but here's the way it works. A court says, well, this may violate the Constitution, but exactly. And then they begin to impose an analysis which is nowhere found in the Constitution, and they say, does this involve a core or fundamental right? And if so, we will use an enhanced form of judicial scrutiny to decide whether the right will sustain, whether the right in the Constitution is more important than the government's interest to suppress the right.
Now that right there is a treasonous concept. The idea that the government has interests. I don't think it's correct at all constitutionally to say that the government has interests. The government only has obligations to the boss, to us.
Well, of course, that makes a lot of sense, and perhaps that's why it hasn't been adopted as a doctrine.
Well, and if I said that in a courtroom, I'd probably be sitting in the penalty box.
Well, we have to. You have to come up with a sophisticated way to invest judges with the power to sit as a continuing constitutional convention to do whatever it is they please. So you have to come up with a way to do that. And the way they do that is to say that we're going to review the case based on one of 3 different levels of scrutiny: the highest, strict scrutiny, or a moderate intermediate scrutiny, or the lowest level, rational basis. And we then weigh the interest of the people versus the interest of the government. And usually, if it's enhanced scrutiny, the people win. Strict scrutiny, the people win. If it's in the middle, you don't know. And if it's rational basis, the government wins. And the problem is that none of this is in the Constitution. This is all atextual. No words support this. And
now,
yet
Hamilton might have gone for that concept, but I think most of the founders would have gotten out their flintlocks again.
Well, the very thought that this doctrine walks onto the world scene in Korematsu in the 40s is sufficient evidence of its tainted origin. And, of course, it's come up in the Second Amendment repeatedly. And even some of the lawyers who argue Second Amendment cases can't get themselves out from under this notion that there are these levels of scrutiny, and we've attempted to straighten out the thinking in many cases on this. They'll come in and say, oh, please use strict scrutiny, Your Honor. We want our clients to win. And the courts say, oh, we're not going to use strict scrutiny. This is a matter of public safety. And,
right.
And of course, the key to the case and how these cases can be won, which is unfortunately a lot of lawyers don't understand, is going back to what Justice Scalia said in Heller, where he said, the balancing has already been done by the people in the writing of the Constitution. The government's interests are trumped by the rights guaranteed by the Second Amendment. Beautiful, clear language, but language which limits the flexibility of justices and judges to do what they want, and they're not very happy with that kind of language.
Am I correct that we have been in a declared state of emergency since Roosevelt declared one in order to go and steal the banks and steal the people's gold?
This is rather extraordinary. Most people don't know that they have lived most or all of their life in a state of declared emergency. Right now, I used to I used to follow this quite closely, there used to be about 13 or 14 concurrent, overlapping, presidentially declared states of national emergency. And they dealt with different issues.
One of them that you mentioned in your paper is one of the things that really gets me, and that was to prevent people like you and me from sending a couple of bucks to Jonas Savimbi of UNITA, who was fighting against the communists that were trying to cement their control of his country, Angola. Actually telling private individuals that they can't send $5 to Jonas Savimbi. That's incredible.
We are on the wrong side of battles so frequently, it's hard to remember when we were on the right side. This use of national emergencies, of the president having the authority to declare a national emergency, what it does is that it triggers hundreds of standby powers that Congress has given to the president
unconstitutionally,
which can only be invoked when he declares a national emergency. So you will see presidents do this on a regular basis. It will be with respect to a particular problem or with respect to broad problems like terrorism.
Terrorism has given us the opportunity for much mischief. Talking with Bill Olson, Gun Owners of America's attorney that does so much of our appellate work on friend of the court cases, defending people being beat up on by the feds and sometimes the states. His website is lawandfreedom.com, and we're going to be back with another segment and talk about executive orders. My guest is Bill Olson, constitutional attorney. Website is lawandfreedom.com. Bill, one of the really outrageous acts of presidential power being abused, you mentioned in your paper, Executive Orders and National Emergencies. Clinton probably stole more land, as far as I can tell, than any other single politician. No authority to do it, but he just went out to Utah and grabbed up over 1 million acres and said nobody can do nothing with this land. Actually, it would be a great invitation for the sheriff of that county to invite mining companies to come in and start operations and invite the feds to stay out. But this was incredible. It came out of nowhere. As I recall, it may have been right at the end of his term, but I'm not sure of that. But he pulled off this land grab, and we really don't hear a whole lot about it.
Well, this really was something. At the time, it was a very big issue, and now most people probably don't even remember it. But this was one of those situations where the Congress was in the process of considering legislation to declare this vast tract in Utah as a national monument of some sort under various laws that exist. And the president at some point said, while you consider, I'm going to act.
I can't wait for Congress. This is a national emergency. Why, the Angolans may attack.
Well, this is, of course, we buy into this. The greatest power that the federal government has is the ability to inspire fear in the people. And if they inspire fear in the people, they can get away with anything. And that's why we have to be aware of their devices and their techniques, because they use the same playbook, administration after administration, and they tell us we're about to go to orange level, red level attack, whatever. We had a heightened state of terrorism. We've gotten intercepts, high level of reliability.
But we can't tell you what they are.
Yeah. And at some point we just have to say, God's in control. Everything's okay. Whatever you're saying is not going to inspire fear in me, because the moment you become fearful, you make a bad decision.
After all, it's pretty clear in Scripture that God has given us a spirit not of fear.
Exactly.
And so when we catch ourselves thinking in a fearful manner, we have to realize that's not of God. Satan, get behind me. Now, what do I need to know? What do I need to think through this situation so that I can do it in a way that's not going to be done from fear. I think you just made a really great point that all of these, well, we call them emergencies. The presidents have told us the sky is falling. And chicken littles that we are, run around and say, oh, well, please don't let the sky fall.
A lot of this goes back to 9/11 and the legacy. The immediate effect of what Congress did was to pass the AUMF, the authorization for the use of military force. And I'll just give you a quick paraphrase of that. It said, Mr. President, we are scared to death. Somebody just attacked us, and we don't know who. So we in the Congress want you to figure out who did it and who might do it ever again. And for the foreseeable future, which as long as the war continues, which they've told us is permanent now, we want you to do whatever you need to do to protect us and stop it from happening again.
You know, even a socialist like George Orwell saw where that kind of thinking goes. And his 1984 was the nightmare that this socialist had that, oy vey, that's where my socialism ends up. Maybe we better think this through some more. So if let's see if we can't be at least as clear thinking as George Orwell.
Well, this is where it all began, because at that point the president said, well, look, the people have spoken through Congress, and I'm supposed to protect them, so I have to surveil them continuously. I have to violate any at last vestige of privacy that they may have. I need to stop things from happening in advance, which of course is not the role of government. The role of government is to punish evildoers after they've done it. It's not
right.
To anticipate things and say, oh, you may create a problem in the future, and therefore we're going to take you off the streets today.
We're the ones that are supposed to be the first responders, and if those airplanes that were converted into IEDs, improvised explosive devices, had been flying under the rules that we had in the air in the early 60s, very likely a passenger would have gotten up and popped Muhammad right in the head with a .38.
Well, at some point we have to realize that bad things happen. It's a lost and fallen world, and that we can't be protected from everything, because if we want to be protected from everything, then we fall into Ben Franklin's advice there. We have traded away for our security all of our essential liberty, and we are slaves. And, of course, we're not going to be any safer then anyway. But here's the authorization for the use of military force, and the political pressure from the people was so great to do something that this outrageous bill gets passed. And what's the vote? 420 in favor, 1 against, 10 not voting.
Certainly one cranky individual. But we don't have much time left, but I did want to just briefly touch on one of the president's many executive orders, one dealing with gun violence reduction, that calls, it says that doctors are not prohibited from asking patients about guns in their houses, even though that's an ethical violation for doctors. And even though Obamacare, the one good thing that we were able to get in there that I'm aware of, was a prohibition on doctors being directed to ask for that by the federales.
You know, this is amazing. If the law goes through because it protects gun owners, we simply can't trust what these people write on a piece of paper, because right. They now have their lawyers come in and say, oh, we are going to issue supplemental instructions interpreting the language in the Affordable Care Act, which has been incorrectly asserted to prohibit doctors from asking patients about guns and gun safety. And we believe that that is not what the purpose of the law is. So we're going to ignore that provision, and you can follow our administrative guidance, all you doctors and hospitals out there, and disregard what is in the law. It's an extraordinary thing. When one wonders to what extent we live under the rule of law, we're almost entirely under the rule of man.
And I think we, the people, are not demanding that of our politicians. We don't know what due process is and what a limited government under a constitution is all about. We don't know that the Constitution doesn't direct us to do anything. It only instructs government on what little is expected that they should do. Maybe I'll close with this. When I was sworn into the Virginia legislature, I cracked my right elbow and I was in a cast. So I had to raise my left hand. I kid you not. As soon as that ceremony was over, 3 of my new colleagues came bounding over to where I was located and slapped me on the back and said, "Boy, that's really great. It doesn't count that way, does it?" The law is there to be broken. The law is there to be gotten around. And I'm certainly glad that there are some attorneys at lawandfreedom.com that are not playing that game. So we are very happy that you've been available to do our work for us, Bill Olson. And I wish you many more years of practice. And actually, we don't have too bad a batting average considering how ornery our views are.
It's been a pleasure to work with you on it, Larry.
Thank you, sir. Talk to you soon. I'm Larry Pratt of Gun Owners of America, and I want to invite you to join the Second Amendment movement with Gun Owners of America, the only no-compromise gun lobby in Washington. Take action by becoming a GOA member today by going to gunowners.org. Gun Owners members receive the GOA newsletter, fact sheets, alerts, certificates, and more. But there's more to joining GOA than just a list of member benefits. The united voice of GOA members has been successful in defeating restrictive legislation designed to disarm our population. GOA has helped to get strong constitutional members of Congress like Senator Ted Cruz elected. And with your help, GOA will continue to successfully defend the rights of gun owners in the courts. Participate in our efforts to restore and preserve the nation's right to keep and bear arms. All contributions to our lobbying efforts are used exclusively to support or oppose firearms legislation. Join online at gunowners.org.